They need about 10 more minutes because they just added two more.
If somebody else get started and they
All right.
see if somebody can get started. And then if they want to come on in, I put somebody in the breakout rooms. I mean something. 15 minutes. In already.
Let him go out and he's about to zoom in right now.
Okay, great. Thank you. All right, welcome back, Mr. Moreau.
Hey, Mayor. Judge, I'm gonna need somebody to zoom in at some point and interview if that's Mr. Garrett. I need somebody to interview him. He has not spoken to council yet.
Okay,
We have a bunch of DDCs ready to go. I don't know if it's everything just yet. I think we still have
okay.
1, 2, 3, at least 4 more to interview. But
So Mr. Rico, I think he's gonna interview Mr. Orso. Okay.
unless if we're waiting, then I'll interview Mr. Garrett real quick now.
Howdy, where are we? Since we have somebody from, can we call? Oh, can you call the chief? Yeah, we're ready. Oh, let me get to the screen first. DDC?
Yes, sir.
Okay, how about Justin Johnson? Is that one ready?
Ready
Ready.
for it? I'll bring it in.
All right, Mr. Garrett, we're gonna handle some other matters first, sir. So thank you for your patience.
No problem at all.
All right, sir, at DDC, your name, please?
Justin Johnson, Justin Lauren Johnson.
All right, then hold on. We're waiting for the chief judge who's gonna handle your matter. Well, he has some tickets. So, well, I guess I could go ahead and do those tickets now.
Yes.
Okay, all right, so Mr. Johnson, you failed to appear on some tickets and a bench warrant was issued. Of course, gonna set those bench warrants aside. You do have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. You have the right to remain silent. Anything you say can and will be used against you. Court is calling ticket number SP 1433681. You're charged with loitering. Ticket number SP 1514941. You're charged with disobeying a lawful police order. So for those charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. The court is going to enter a not guilty plea on your behalf, set a personal bond, and you have court date pretrial for June the 27th. It's like, it says 9 o'clock, and that will be before Judge Williams by Zoom, okay?
Okay.
All right, thank you. But hold on, because you have another, no, sir, you're not done yet. That's just for your tickets.
Okay.
You have another matter. Oh, okay, all right. So, can we recall Mr., well, we have a walk-in? That, oh, he's gonna handle that one also. Mr. Urschel's being interviewed. DDC, the chief judge needs a few moments, about 10 minutes. So can we move forward with, Rodney Bragg and Jamil Fuller?
Sure.
Okay, we'll get right back to you, Mr. Johnson. Yeah, they're interviewing him, so they're not ready. Well, we do have McComb on there as well. I need to- All right. Both of you, good afternoon. Will both of you state your names, please?
Jamil Fuller. Rodney Bragg.
Okay. Court is calling case number two. Okay, thanks, Ms. Mary. Case number 2505814-001. The people of the state of Michigan versus Jamil Robert Fuller. He's identified as defendant number 1. And also case number 2505814-002. The people of the state of Michigan versus Rodney Bragg Jr., who's identified as defendant number 2 in this matter. Can I have your appearances, please?
Good afternoon, Lisa Coyle, appearing on behalf of the people.
Good afternoon to this honorable court. Carla Marable, P number 62755, on behalf of Mr. Braggs.
And Ryan Murad, PA 3665, on behalf of Mr. Fuller. We waive the reading and stand mute. Mr. Fuller has been advised of his rights.
Mr. Braggs has also
Okay.
been advised of his rights, Your Honor.
All right, then. The court will enter not guilty pleas on behalf of Mr. Fuller and Mr. Braggs. Ms. Coyle, you have bond recommendations, first starting with Mr. Fuller.
Okay, as to Mr. Fuller, what I see is a 2023 weapon improper transport out of Troy District Court. That's in 2023. In 2024, I see an unarmed robbery under HIDA. And as to 2025, I see an R&O out of 16th Circuit Court. In this matter, he is charged with a weapon, a switch, and also being in a gun-free zone with a weapon. Based on his past convictions, that improper transport, and the unarmed robbery and the R&O, the people are recommending a 5,000 10% with the tether, Your Honor.
Okay, one moment. Let me let Mr. Reagan in. All right, you said 5,000 10% tether
Yes.
was your recommendation? All right, your response, Mr. Murad.
Judge, I'll start. Mr. Fuller is gainfully employed at Ford Motor Company in Wayne. He's got a full-time job there from 6 p.m. to 5 a.m. He's 21 years old, a life resident here in the state. He was very candid about his prior criminal history. He indicated everything that Ms. Coyle told us of. To date, I'm not aware of any sort of violation from the height of probation. Obviously, this charge alone might constitute that, but other than this, it seems that he's been doing well. He's also, Judge, he gets to go to like a school, like a program through his job that his school's paying for, that his job is paying for. I just don't want him to lose that. So that's why I'm hoping the court, if the court's gonna do a 5,000 10%, I'd ask the court not to do tether. Other than that, I would ask the court if it's gonna do a tether to do a personal bond, and to not impose any sort of house arrest or any of those restrictions. I guess without a KPS history though, I don't know that I see the absolute need for a GPS tether. But again, I think that this is a non-assaultive charge on its face. I think a no firearm provision should do it ultimately, Your Honor. So that's what I'm going to ask the court to do. I'm asking for a personal bond, no weapons.
Okay, thank you. All right, So I'm gonna hold off on that decision. Can I hear from Ms. Coyle relating to Mr. Bragg?
Mr. Bragg also admitted possession in this matter. He is charged with a CCW in a gun in a gun-free zone. I note that he has been sentenced or pled guilty, I believe it was, on May 13th of last month. He pled guilty as charged to CCW before Judge Matthews in the Sixth Circuit. So I think by the ROA, he's pending sentence. So for that matter, Your Honor, for another gun charge, within a month of pleading, he has already picked up another gun allegation. So for that reason, people are asking 5,000, 10% tether. Thank you.
Okay, and your response, Ms. Marable?
Your Honor, the purpose of bond is twofold. The purpose of bond is to make sure that the person shows up for court. My client's not a flight risk. He doesn't have a history of CAPIAS, and for the protection of society. He does not have a history of violent crimes or anything like that. At this point, these are just allegations. We're asking for a personal bond, Your Honor. He does have retained counsel, and that these are just, at this point, allegations. He's a graduate of high school, and he is working, Your Honor.
Okay, and what are his hours in terms of employment?
Your Honor, I believe that he works from 9 to 7.
All right, and then Ms. Barada, I didn't inquire your client's hours of employment.
6 p.m. to 5 a.m., Your Honor.
Okay. All right, the court has heard the arguments of the parties, had an opportunity to review the investigators report. I'll start first with Mr. Fuller. Sir, you do have a history in terms of the contact with the criminal justice system. Looks like at least 2 of these involve weapons offenses, and that, of course, is concerning for the court. Because you're employed, the court is going to take that into consideration. You've indicated, Mr. Murad, representing that he works at Ford's.
Yeah, he works at Ford Motor Company in Wayne.
Okay, then one moment. I am going to impose a tether. I am going to set a $10,000 personal bond for both. As it relates to the tether for Mr. Fuller, he will have curfew hours, 5 a.m. So he'll have 8 p.m. to 3 a.m. And then Mr. Braggs works
Judge,
7 a.m. to 7 p.m. Yes.
I just want to make sure it was clear. Mr. Fuller works 6 p.m. to 5 a.m. So I think he can be in the house between 6 a.m. and 5 p.m. Or, I'm sorry, 6 a.m. to
6 p.m. to 5 a.m. We had it back.
Oh, I'm sorry. He works 6 p.m. to 5 a.m. Okay, I got it. I had it backwards. Okay, so if he gets off, I want him to be able to get home. So he should be home. So 7 a.m. to 4 p.m.
that works.
Okay. All right then. And Mr. Braggs, he works 9 a.m. to 7 p.m. So his hours will be 9 p.m. to 7 a.m.
Okay.
Okay. He also has a $10,000 personal bond. All right. Mr. Fuller, sir, while you're on bond, you're not to possess or purchase a firearm or any other dangerous weapon. And the same applies to you, Mr. Bragg, not to possess or purchase a firearm or any other dangerous weapon. Both of you gentlemen, you have a probable cause conference that's scheduled for June the 23rd at 8:30. That'll be by Zoom before Judge Jefferson. And then you have the right to a preliminary examination. Hold on one moment. Oh, I thought the chief was here. You have the right to a preliminary examination. That's scheduled for June the 30th at 8:30. However, that will be in person before Judge Jefferson here in the 36th District Court. Make sure you both comply with your conditions of bond, keep up with your court dates, so you don't jeopardize your freedom. Okay, Ms. Marable, is there anything further?
Thank you, Your Honor.
All right,
Mr.
Mr.
Bragg, when
Murad.
you get out, give me a call. You got a personal bond. Thank you.
Mr. Murad,
Nothing further, Judge.
Ms. Porter. Okay,
Good walk.
No,
Okay. I'm gonna go,
he's already interviewed him.
yeah, I'm gonna go represent him in the lockup in person.
here you guys.
Yeah, and I have a lockup.
Oh, okay.
Sorry, Kayla. We have one number we still need to put on there, the Washington number.
Hey, we can hear y'all.
With this gentleman that's in Macomb County, he's been waiting a while. I'm sorry, Mr. Reagan, were you saying something?
I said, hey, Judge, how are you this afternoon?
Okay, what you need, Mr. Reagan?
I'm waiting for Judge McConicle to do the walk-in campus run.
He called down and said he needed a few moments, so he has not zoomed in yet, just yet.
Judge, can you put in Mr. Reagan with Mr. Garrett from Macomb?
Fine.
Also,
Okay.
we got 2 females to interview.
Okay, Mr. Garrett at Macomb, did you indicate to the court you have been interviewed, sir?
No, I haven't been interviewed.
Okay, oh, you said you needed to be interviewed. Okay, so Mr.
Correct.
Reagan, you want to speak with him first? Create these breakout rooms. Okay. And sign for open all rooms. Okay, I feel Reagan.
They both
Mr. Braco, ready?
Yes, Judge, already on, Mr. Russo, who's in the back right now.
I understand the chief judge is going to handle at least one of his matters. I could handle the other one, and then he also has a matter, if you don't know, before Judge Holmes. But those are tickets, so you
Yeah.
don't have to worry about those.
And I
Okay.
have one, correct, Mr. Washington? Judge McCaffrey?
And Mr. Johnson,
Mr. Johnson?
yes, Mr. Johnson, and Mr. Washington, and Mr. Orso.
Oh, all 3 of them.
He has a KPS as well. He has a regular arraignment, and then he has a KPS.
Okay, I'll be handling all of them. I'm just gonna grab Johnson.
Okay, all right, thank you. Okay, let me get this in here. All right. Oh, these are the 2 new people. Okay, there we are on Mr. Bragg's and Mr. All right. Okay, is there anybody that we can do in the meantime while we're waiting? Yes, sir. Maybe, say we could get going on Mr. Orso's other case. The walk-in, that's, what's your name, sir, Mr. Johnson? Is that Mr. Johnson?
Washington.
Oh, that's Mr. Washington.
Yes.
He has a KPS, I think. Yes, so I can't do that one. So, let's see if we can, all right, Mr. Reagan.
It's ready on Monroe County, Judge.
Okay, so that is Mr. Garrett.
Yes, sure.
Yes.
Yes, sure.
Okay, Ms. Coy, you ready on Garrett?
Yes, I am.
Okay, thank you. All right, Macomb County, oh, are they stuck in there? Hold on. Might still be in the waiting room. Main session. All right, this is Mr. Garrett. Sir, would you state your name for the record, please?
Jonathan Garrett.
Okay, thank you, and thank you for your patience today. Court is calling
No
case number
problem.
2505-793-901. The people of the state of Michigan versus Jonathan Al Capone Garrett Jr. Okay, can I have your appearances, please?
Lisa Coyle, appearing on behalf of the people.
Philip Reagan on behalf of Mr. Garrett, Your Honor, waive the reading, stand mute. He's been advised of his rights, Judge.
All right, then the court will enter a not guilty plea on behalf of Mr. Garrett. Okay. Somebody's chiming in on an iPhone. Okay, Ms. Coyle, bond recommendation.
Your Honor, currently it appears Mr. Garrett is on a parole hold. He began his parole in February of 24. He's on parole for home invasion first, 2 counts of armed robbery and felony firearm. The allegations, his parole does not end until June of 26. The allegations that he pointed a weapon at the complainant, Mr. Sims, on Van Dyke, and that gun was recovered. So I don't think this is much of an issue. I don't think he's going anywhere because of that hold. But the people are going to ask for a 25,000 cash surety at this point, Your Honor. Because I'm not sure if that hold is, because usually there's a deputy there. I can ask if that parole hold is valid. I'm reading it off of Otis, so that's why I'm asking for that.
Judge,
All
I'm
right,
asking,
Mr. Reagan.
I'm just asking for a personal, but I think the allegations are what they are. You know, it's a FA alleged pointing a gun. My client's going to say he didn't do it. The gentleman's going to say he did do it. Yes, they recovered the gun allegedly, Judge. It's going to be a FIP case. I don't think a $25,000 cash bond is necessary in this case. Personal bond could suffice. As Ms. Coyle said, he's out of parole detainer, Judge. So, I just don't think a cash bond is necessary, though.
Okay, one moment, let me just see here. Was the chief gonna check in on, from the courtroom Zoom, Cause I have somebody on.
I wouldn't do that.
You know what, I was gonna do, and put the remove real fast, so.
I mean,
Oh, wait, let's go ahead and finish this. Okay, so you want personal bond in terms of, what's pending? You want to get any credit?
well, you got a parole hold, so I don't know if
That's true.
entitled to credit.
That's true. Okay, all right, so, Ms. Coyle, I see no need for a cash surety. bond in this matter. The charges are serious, but the court is going to set a $20,000 personal bond. All right, so Mr. Garrett,
Yes,
sir, I
ma'am.
understand you are in custody, but you do have a condition not to possess or purchase a firearm or any other dangerous weapon, okay?
No problem at all.
All right. And you have two court dates. You have a probable cause conference that's scheduled for June 27th at 8:30. That'll be by Zoom before Judge Giles, and you have the right to a preliminary examination. That's scheduled
Can,
for
can you
July
repeat
the
that date?
3rd. The first one is June the 27th, 8:30.
All right.
Judge Giles. It'll be by Zoom. And so they'll send something to the jail and they should give you the paperwork, okay? And then your
Yes,
next
sir.
court date, if you want to write it down, that'll be July the 3rd. That's a preliminary examination. That's at 8:30, but that one will be in person.
All right. Appreciate it.
Okay, all right then. Also, I said no weapons and you're not to have any contact with Monte Sims. All right? That means no
No problem.
phone, no messaging, no nothing. All right. All right, that concludes this matter. Thank you.
All right, thank you, Your Honor.
Nothing. Okay, so we're still waiting, Mr. Orso. He's waiting patiently.
Am I free to go?
Oh, yes, your case is concluded. So just make
All
sure you
right.
get your paperwork with your court information on there. They should Zoom you in since you're in custody on the
All
appropriate
right.
dates, okay?
All right. Appreciate it. You have a nice day. You say y'all go down the paperwork for me?
He ready to get this paperwork. Okay, the clerk is calling him. Okay, I thought that was Theo. Okay, tell him chime back in. I was gonna go to it. He was on the,
The Chief Judge on a regular iPhone?
Does it say 720?
no, it's just said iPhone on there.
Hmm.
So, but if I know this is,
Yeah, I let him
okay,
know.
we weren't sure.
We'll let him
Okay,
know.
well,
Thank you.
yes. I'm blaming on you, Phil. So he
Blame it
do-
on me. Yeah, blame it on me. You put it. I'm gonna tell you, you gotta put your name on stuff. It's the day and age. You gotta put your name on it.
You know, I mean, you
And then that
probably-
doesn't
yeah.
always help.
No, that's true.
I take the blame. Put it all on me.
Okay. She said, don't do it.
Yeah,
Don't do it.
Not-
She told the magistrate not to do it.
yeah, I said, not like.
Okay. Yes, okay. All right, then let's get these individuals ready. So we can get Mr. Washington up since he's in the courtroom.
Magistrate Burton, can you hear me?
Yes, Your Honor. We're-
Okay.
You ready for your matters?
Yes. How many do we have?
We have 3.
Okay.
Okay, the first one is a walk-in. He's at the podium.
All right. Please call it.
Okay, all right, then, sir, would you state your name for the record, please?
David Ross, Washington.
All right, court is calling case number 25057873001. The people of the state of Michigan versus David Ross Washington. Mr. Washington, is charged with police officer fleeing and eluding 4th degree. There's also a habitual offender 2nd offense notice attached. There was a capias issued on June the 13th. Wait a minute.
That's today.
This morning,
Today.
this morning.
Okay, that was this morning by Judge Patricia Jefferson. The bond that was set was 1,500, 10%, and that was at an examination.
Lisa Coyle, appearing on behalf of the people. Good afternoon.
Good afternoon, everyone. Miguel Rico, P88379, appearing on behalf of Mr. Washington, who appears in person today to my right. Judge, my client advises constitutional rights, waives forwarding complaint, stands mute, requesting not guilty plea be entered on his behalf.
Not guilty plea will be entered. Argument.
Your Honor, I think based on the fact that this was a failure to appear today, I'll defer my argument first to defense counsel for his client's explanation.
Thank you, Ms. Boyle. Judge, on behalf of Mr. Washington, we discussed this today. He just showed up to court late today and he stayed and he asked for another court date. And I made him aware that there's a bench warrant out for his arrest and that we would have to go in front of the chief judge of this court to ask for leniency and allow him to walk out today on a personal bond and come back to court. He did show up to his probable cause conference. He missed today based just on time. He was in court, he showed up, he just missed it based on time. I would ask for some leniency. His habitual is nothing since 1992. It dates back over 25 years ago. And the underlying offense that we're here for today is not assault of judge. I think he understands to come to court. It's just a problem. He's willing to take care of it. I would request a personal bond.
Ms. Coyle?
Your Honor, I have no objection in reinstating the 15,000 personal bond. He did walk himself in. He was tardy to court, and I don't see any other failure to appear.
Bond will be reduced to 15,000 personal. Sir, make sure before you leave, you get your new court dates and you're very clear. And don't get there at the time to schedule. Get there early. And that's all. Thank you.
Okay. DDC, can we have Justin Johnson back up, please? You want Mr. Washington's court dates while they're bringing out Mr. Johnson? The probable cause conference is June the 23rd at 8:30. That'll be by Zoom. And then the preliminary examination is scheduled for June the 30th at 8:30 in person, again, before Judge Jefferson.
Thank you.
Okay. All right, sir, would you state your name, please, for the record?
Pastor Lord Johnson.
Okay, good afternoon again. Court is calling case number 2505754-201. The people of the state of Michigan versus Justin Loren Johnson. Here's, Mr. Johnson is charged. He's charged in count 1, weapons, firearms, possession by prohibited person. Count 2, weapons, ammunition, possession by prohibited person. Count 3, weapons carrying concealed. Counts 4, 5, and 5, felony firearm, and there's a habitual 3rd offense notice attached. Let's see. Failed to appear for preliminary examination on 5/29/25, and Judge Giles set bond at $30,000 cash.
Appearances.
Lisa Coyle, appearing on behalf of the people.
Judge Miguel Rico, appearing on behalf of Mr. Johnson, appearing via Zoom today. My client advises constitutional rights, waives full reading the complaint, stands for requesting not guilty plea be entered on his behalf.
All right. Argument.
Your Honor, the people see 30,000 cash. There's only one failure to appear, but Mr. Johnson has a record. He does know how to come to court. He should have been timely. I do not believe he turned himself in. That would change my mind about what I'm going to ask for. I'm recommending a 10,000 personal to be reinstated, but with the tether.
Okay. Defense,
Judge, we have, on behalf of Mr. Johnson, I would have no objection to that personal bond being restated with a tether.
bond will be set at 10,000 personal with a GPS tether. The curfew will be 10 p.m. to 6 a.m. And no possession of weapons of any kind. Thank you.
Thank you.
Okay,
You're free, sir. Free to go.
the court dates. The clerk is asking for the court dates, Your Honor. He has a probable cause scheduled for June the 24th at 8:30. He also has a preliminary exam scheduled for July the 1st at 8:30. All right, then, we have Mr. Urso. Yes, we're ready. Yes, we're ready. Mr. Washington. I don't know if the court can see, but Mr. Orso, he is in a wheelchair, Your Honor, so they're bringing him in.
Okay.
He doesn't have to stand up. If it's. Okay, all right. Good afternoon, sir. Would you state your name for the record, please?
Christopher Ray Urso.
All right, court is calling case number 23-0603-6601. The people of the state of Michigan versus Christopher Ray Urso. Okay. Mr. Well, I guess you're going to say your appearances and then I can state what he's charged with.
Lisa Coyle appearing on behalf of the people. Sorry.
Miguel Abrico, appearing on behalf of Mr. Urso, who appears in person to my right today. My client's been advised of his constitutional rights, waives a formal reading the complaint, stands mute, requesting not guilty plea be entered on his behalf.
Not guilty plea will be entered in.
Okay, Your Honor, Mr. Urso is charged in count 1 with breaking and entering a building with intent. There was a capias issued on, looks like 1/16/2024. Failed to appear for a preliminary examination, and Judge Sabri set a bond at $1,000 cash surety.
Argument.
Your Honor, this was on, he had a case on, this happened on December 7th of 23. His other case that's before the court today, but it's an attorney general case. There's no capias. He's yet to be arraigned. Occurred on December 10th of 23. So within a few days, he was arraigned on the case before you on December 9th. So the next day he went out and picked up allegedly a larceny in a building case. The people have no objection to converting that 1,000 cash surety to a personal, but I'm asking for a tether in this matter since he has not turned himself in, as far as I'm aware.
Defense.
The personal bond, Judge, very briefly, I know you can't see my client probably through the screen. My client has a left leg amputation. He's in a wheelchair today. This is the very first, and it's a rare thing for me where my client actually suggests what they think their bond should be. My client himself said that he would love a PR bond with the option to tether to rehab. He acknowledges that he has an addiction issue and he'd like to go to rehab. He is homeless, Judge. I don't know what kind of complications that comes with when we try to tether, but he has indicated to me that he would love to exit the jail today and go to a rehab center. I would just like to state that for the record. If we were to tether, it would be probably to a center and not to a home, as he doesn't have permanent housing.
Court haven't heard the arguments of counsel. Court finds $1,000 bond to be an unaffordable bond. The KP is $1,000 bond. Bond will be reduced to 1,000 personal. The court is not going to issue a tether based on the defendant being unhoused. Magistrate Burton, please inform the defendant of his court dates. And that's all.
Okay, thank you, Your Honor.
Do we have any other cases, Magistrate Burton?
No, Madam Clerk, that's the last one, right? That's it, Your Honor.
Okay, thank you very much.
Okay, all right, thank you. Okay.
Everyone have a great weekend.
You too.
You as well, Your Honor. Okay, so his court dates, he has a probable cause conference that's scheduled for June 24th and a preliminary examination scheduled for July the 1st. All right, the one on the 24th will be by Zoom. The one on the 1st will be in person. Both of those at 8:30 before Judge Taylor. Sir, while you're on bond, it says that you may not enter that auto zone or go to that auto zone on West Vernon. You understand that? Okay, he has another matter. So I'm gonna call that. Would you state your name again for the record, please?
Christopher Ray Urso.
All right, court is calling case number 24058-65501. The people of the state of Michigan versus Christopher Orso. Appearances, please.
Your Honor, this is the AG matter. I will not be appearing. Thank you.
Okay, thank you. Mr. Frico?
I believe I will be appearing for arraignment. Would you mind reading the complaint for us? I do not have that complaint. I just have the deed.
Okay, and count, it says that on, let's see, the date is 12/10/2023. It's the people of the state of Michigan versus Christopher Orso. In count one, he's charged with safe breaking, carries up to life or any term of years. And then in count two, he's charged with larceny in a building, carries up to 4 years.
Thank you. Michael Brick on behalf of Mr. Secretary today, and first is my right. Judge, he's been advised of his constitutional rights, waives the formal, well, we've read the formal reading, but we would waive regardless for purposes of the record. Stands be requesting a not guilty plea to be entered on his behalf.
Okay. All right, then the court will enter not guilty plea on behalf of Mr. Orso on this particular matter. The court is gonna set a $5,000 personal bond. Unless there's some objection to Mr. Frico.
No objection, Judge.
Okay. Now, Mr. Orso, on this file, you may not go to or enter the MGM casino. Okay, all right. So you have 4 dates. You have a probable cause conference that's scheduled for 6/24. Is this the same? Can we have the?
Could I have this written down for me?
Yeah, you have the same, you'll get some paperwork before you leave. Same court dates as before. June 24th at 8:30 is your probable cause conference. That'll be before Judge Taylor by Zoom. And then you have the right to a preliminary examination. That's scheduled for July 1st at 8:30, but that one will be in person before Judge Taylor, right here in the 36th District Court. If you have any issues relating to Zoom, then come to the courthouse in person, okay? All right, then. Is there anything further, Mr. Frico? All right, that concludes this matter. All right, this is on a KPS file.
I'm gonna head back on the seat.
Okay, thank you. This on that file, and then I'll get Mr. Johnson. All right, DDC. All right, you're welcome, sir. Take care. Okay, we're ready to go. Thank you for your patience.
Henry Kennedy III.
Okay, one moment, sir, and good afternoon to you. 1 minute. Okay. Okay. All right, and this is the last one on the KPS. Thank you. All right. All right, the court is calling Do we have anybody that's handling Mr. Kennedy from MFD? All right, Mr. Brick. Oh, yeah, okay. Not in person, not your Zoom, man. How did you do
Yeah,
that?
right.
All right, court is calling case number 2505813901. The people of the state of Michigan versus Henry Kennedy III. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Judge Miguel Brico appearing on behalf of Mr. Kennedy III. Judge, my client's been advised of his constitutional rights, waives the formal reading of the complaint, stands mute, requests a not guilty plea be entered on his behalf as to all counts.
All right, that the court will enter a not guilty plea on behalf of Mr. Kennedy. Ms. Coyle, by recommendation.
Your Honor, could you ask the jail if there's a parole hold on him, please?
Yeah, DDC, does Mr. Kennedy have a parole hold?
Yes.
That was a yes?
I'm sorry, I didn't. You said yes?
Yes.
Okay, thank you. So yes, Ms. Coyle.
Okay. My recommendation, even though there's a parole hold, I'm asking based on the severity of what occurred and the dangerousness of it, the outright dangerous to the community. I'm asking for a 50,000 cash surety. Of course, no driving if he's the parole hold is released. But my guess is it will not be. It began July 18th of 24, and it's supposed to end his parole in July 18th of 26. I also see him on probation for drug delivery out of Virginia until 2030, but that's probation, is my understanding. He's on parole, as I said, for a home invasion second right now. But in this matter, Your Honor, the allegations are severe. That the allegations are that he swerved his car into the victim's car and that hit the passenger side and pushed that Ms. Reed's car into oncoming traffic that hit another car, in which that car, those two people sustained injuries. We have allegations from several witnesses that there was an argument between Mr. Kennedy and Ms. Reed prior to this, and that there were Facebook messages that he stated that the victim was in the hospital because she attempted to run him off the road, showing photograph damage to his own vehicle. And other witnesses heard him threaten the complainant himself. So the injury to the other complainant, Ms. Colston, was a broken femur and 2 toes. There was also a 9-year-old that had a broken femur. The speed limit in that area was 30 miles an hour where the crash occurred. Now, he's not charged with an assaultive crime. He is charging with failure to stop, because I believe that the proofs may not be there as to the assault, but we do have that it is him that who alleged caused the accident, and that those are the allegations because it's on a video. There were also police reports filed previously by the complainant in this matter that he had punched her multiple times in the face. Officers observed injuries to her nose, a bruised face. He allegedly choked her and pulled a gun on her. That's in the IR, as well as the second report filed that he had hit her and bloodied her face or her face. So, Your Honor, based on the seriousness of the allegations, the fact that somebody died, the fact that he's been on parole less than a year, and he's using the vehicle as a weapon. That's why the people are asking for that high cash surety bond. Of course, if he is released from his hold, I'm asking for the condition of no driving as well, and no contact with any of the complainants. Thank you.
Okay, thank you. Mr. Brico.
Judge, on behalf of Mr. Kennedy III, I'd obviously start off with a few boilerplate statements. Obviously, Mr. Kennedy III is presumed innocent on all of these charges. He's not guilty at this moment and may never be found guilty unless proven beyond a reasonable doubt. I just want to point that out for the record, Judge. In addition to that, as it was indicated by the people, in 2012 is when Mr. Kennedy III had that home invasion offense over 13 years ago. In 10 days, it will make it 13 years exact, actually, Judge. So just a long stretch of time with nothing really occurring. I'm not at the Burger King location in Bloomfield Hills full time. My client expressed to me that he has no issue if this court were to impose a tether, monetization, home confinement, any type of situation they deem fit to keep him, basically keep the general and the specific public safe, even though, in my opinion, I don't think there is any risk of harm to the general public. It appears that this incident was between related individuals, and it appears that that's where this all stemmed from. In addition to that, Judge, I would just like to state that any amount of bond would be unaffordable for my client. Any amount of bond will effectively operate as pretrial detention. He is currently on a parole violation hold. I feel that that might last long enough to give us a good cool down period to where this court can be assured that when he exits the jail, there won't be any feelings occurring from this incident that could cause any harm to anyone. As far as failures to appear, he's been on parole for quite some time. He was serving a sentence for quite some time. It appears that he's familiar with how court works, and I'm assuming that he knows to show up to court since he's successfully made it to parole. And I would ask for a personal bond, no objection to any other conditions this court deems fit, as well as a home confinement condition, if so be it. Our main goal is to not punish any of our clients or keep them in pretrial detention due to the unaffordability aspect, Judge.
Okay, thank you. All right, this court did have an opportunity to review the investigator's report, and I've listened to the arguments of counsel. These are very, very serious charges, and it's unfortunate based on these allegations how an argument spirals out of control and it leads to someone using a vehicle, which is a weapon, and hitting the person who you're angry with, their vehicle, and then they hit another vehicle, and those people are injured, and the person whose vehicle was struck, Ms. Reed, ends up succumbing to her injuries. And so, very, very sad situation. He's charged with failure to stop at the scene of an accident resulting in serious impairment or death, and then the injuries as well. They're not, as Ms. Cole would say, intentional type assault cases, but the act itself in terms of ramming the vehicle, which unfortunately led to the death of one person and the serious injuries of two others. With that, the court does find clear and convincing evidence that a cash bond is necessary, although he is untethered, although he is in custody and on parole. I'm not going to impose a tether because of that reason, but I am going to impose a $50,000 cash surety bond. Mr. Kennedy, sir, you're not to have any contact by email, messages, or mail, directly or indirectly, with Cartier Bracy or Kadasha Colston.
Homicide manager. I don't know what she's talking about. That story she just read is wrong. I was not trying to
Mr. Kennedy, you have the right to speak. I would advise you not to speak. Nothing that you're going to say, especially in front of the prosecutor, is going to help your case today or in the future. If they read you the charges today, as I read them to you prior, that is what the state is charging you with at this moment. I really advise you not to speak with anybody right now at the jail, on the jail phone. I would wait until you speak with an attorney, either in person or in a confidential setting.
Okay, so Mr. Kennedy, sir, I'm certain that you will have your day in court as it relates to these charges. But that's okay, don't apologize. You have your day to explain yourself if you so choose. But today I'm just setting the bond, and I'm reading from the complaint in terms of the charges. I've also read the report, and I know that some of this incident was captured on Myovision. And so, there's a video as well of what is alleged to have transpired. The court's taking all that into consideration, but you will have your day in court. As for bond, again, it's set at $50,000 cash surety, and you're not to have any contact with those parties, okay? You have 2 court dates. You have a probable cause conference that's scheduled for June the 23rd at 8:30. That'll be by Zoom before Judge Giles. And then you have the right to a preliminary examination. That's scheduled for June the 30th. at 8:30 before Judge Giles, but that one will be in person. So they'll likely Zoom you in or bring you if necessary. But those are the court dates. Also, I mean, they have no driving without a valid license, but that's, I'm gonna put it on here, because you might, once you finish in 2026, then you'll have to address this situation, if not earlier. Okay. All right. That concludes this matter.
Free show. Where you locking it? Where are you locking it? I mean, excuse me. Don't, excuse me, don't put me with no attitude. Where are you locking? Okay.
Oh, his bond redetermination hearing date. DDC, can you bring him back a moment? DDC, can you bring Mr. Kennedy back briefly? He has a bond redetermination hearing date I need to place on the record. Ms. Rico, you let that one get by me. Okay, so Mr. Kennedy, you have a bond redetermination hearing on Monday. That's June the 16th at 9 o'clock. That will be before Judge McConicle or Judge Williams, okay? All right, that concludes this matter.
You asked what that means? That means on June 16th, another judge is gonna look at your case and determine if we can lower your bond.
Okay, thank you, sir.
No problem. Take care.
So I'm sorry, I didn't hear you, but I'm
No
glad
problem.
your lawyer
It's fine,
addressed
Judge.
it. Okay. All right, let's see who's next. And sir, your name, please.
President Crenshaw.
Okay, good afternoon. The court is calling case number 25-058-13801. The people of the state of Michigan versus Reginald LaShawn Crenshaw. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Judge Miguel Abrico appearing on behalf of Mr. Crenshaw. My client's been advised of his constitutional rights, waives the formal reading the complaint, stand mute, respectfully requesting a not guilty plea be entered on his behalf.
Okay, then the court will enter a not guilty plea on behalf of Mr. Crenshaw. Ms. Coyle, your bond recommendation.
My bond recommendation, this is a 20-year offense. I do see a criminal history. He has a 1994 murder 2, which he received a sentence of 20 to 40. He does have an assaulted background. This occurred allegedly 2 days ago. The complainant in this matter is his wife, who is estranged from. They are getting a divorce. Apparently the 9th of this month, that was the date of the divorce that they were supposed to go to court. He allegedly asked her, "Are you still going through with it?" on the 10th. And then on the 11th, the date of the offense, he was upset because she didn't come home. There's allegations that he's a heavy drinker, and that he told her on that date of the offense that he was going to set the house on fire. The police found a propane tank at the location. There was also a fire, and there was heavy charring to the primary bedroom. Your Honor, this is extremely dangerous. This is the marital home where they live still. There's an ongoing divorce. Allegedly, he's maybe using alcohol at this time. That's what the allegations seem to indicate. For this reason, the people are asking for a $50,000 cash surety. I'm asking for no contact with the complainant or the residents. I don't even know if the residence is habitable at this point. I'm also asking for an alcohol tether, because I think that may have part of it based on the facts in the IR. I'm also asking for a tether to keep him away from her. this is a highly emotional, volatile situation, in which obviously, whether it be the drinking alone, but that caused him to get to the point in which to set a fire to the marital home, which could cause the death of her, both of them, or anybody in that house. So for those reasons, Your Honor, I'm asking for that high cash bond with those tethers. Thank you.
What was your recommendation?
50,000
I started
cash
writing.
surety.
All right. Okay, your response, Mr. Rico?
Judge, on behalf of Mr. Crenshaw, initially stating as we do that he is presumed innocent unless proven guilty beyond a reasonable doubt. He's innocent of the charge alleged against him at this very moment. Judge, he has a second-degree murder charge stemming back over 30 years ago. I just want to point that out for the record. It is over 30 years ago. The incident at hand, not even looking at the underlying charge, if the allegations were taken on their face, do seem to stem from a isolated incident between two individuals in which emotions, such as the state said, were going high. I think that this court can protect the general and the specific public through other means than pretrial detention. Any amount of bond, especially a $50,000 bond, is going to be unaffordable for my client. He's gone 30 years since having any major contact with the criminal justice system. We as defense have no objection to any other conditions that this court deems fit other than this monetary condition in which we find ourselves leaving people in pretrial detention simply for the mere fact that they don't have money. I would request that Mr. Crenshaw exit the DDC today on a personal bond with any type of tether requirements this court deemed fit, whether it be alcohol monetization, specific monetization, GPS, whatever you think is necessary to protect the complaining witness in this case, we completely understand. I would just also like to point out that while this is pointed out as an arson case, the incident report itself mentions heavy charring and soot to the rear master bedroom and minor soot damage throughout the rest of the house. So we hear arson and we hear these things and we think, wow, he burned a house down, allegedly. And we have, a bedroom impacted at the worst and a little bit of smoke damage from what it sounds like. Judge, I think given his age, his lifelong history in the state of Michigan, the specific circumstances surrounding this allegation, a personal bond will suffice. Any amount of bond is unaffordable. No objection to any other requirements that this court deemed fit. He does have a job. He's gainfully employed by International Exclusion Corporation.
Your Honor, I'd just like to make the comment that because I've heard this argument.
Ms. Coyle.
I'm sorry.
One moment.
I'm sorry.
I had a question for Mr. Brico regarding the work hours.
Yes, Judge, that's one thing my office neglected to get, and I would have no problem putting that on the record right now with my client, if you don't mind.
All right, then, Mr. Crenshaw, would you like to indicate to the court what your work hours are?
My work hours 4:30 a.m. to 3 o'clock p.m.
Okay, continue, Ms. Coyle.
No, I would just, because I keep hearing this argument, he had a conviction in 1994, yes, but he received 20 years in prison. So at 20 to 40, so I don't know when he was paroled, and I don't know if Mr. Rigo knows when he was paroled. So it's not an argument really that we should be stating that he has been crime-free. He's been in prison. So I don't know if he has tickets in prison or what, unless you, but I think to say that he has not picked up any cases because he's been in prison.
He could pick up cases in prison.
Yeah, and I don't know if you looked to see if he had any tickets before you make that argument to the court. Because I know I haven't. Oh, anyhow, I rest on my argument. That's all.
Oh, thank you. So the court, looking at this investigative report, I'm hearing the background information relating to Mr. Crenshaw, lifelong resident and working. And sir, divorces can be challenging. They're emotionally charged between both parties. But the response that allegedly took place on June 11th is extremely concerning to the court. there was not only firing to the bedroom, heavily they said in the bedroom, and I guess other areas not so much, but it doesn't even matter if there was a plant pot that was burnt on the porch. It's still actions of setting a fire because you didn't like what someone said related to the relationship. When it's over, it's over. And that's really unfortunate, the response that is alleged to have taken place on that date. Based upon the fact that there was a fire being set, the threats, the consumption of alcohol, the propane tank that was found in the basement, this really, really could have been a more serious charge. So this court is responsible for ensuring that you come back to court as well as protecting the community. And the complaining witness in this matter, Christina Crenshaw, is a part of the community. I find that you pose a danger to her specifically. I guess Tiffany Brown. Who is Miss Brown? Is that the thought? I'm trying to remember.
I think she may be, I took it as possibly the child of Ms.
Miss
Brown.
Crenshaw.
Oh,
Okay.
Crenshaw, I'm sorry, Ms. Crenshaw. That is not related to, or is not Mr. Crenshaw's.
I believe she's the homeowner, if I'm not mistaken, based on the
So whoever
request
she is,
report.
whatever,
Okay,
whatever the nature of the relationship, he can't have any contact with her and stuff because it again is if she's the owner, it was her property that you know.
They were
was
renting,
burned.
so that's probably likely. Thank you. That is probably.
Okay. Then thank you. All right, so based on those factors, the court does find him to be a danger to the community. And I am going to set a cash surety bond in the amount of $50,000. A moment. And the court is going to also impose a tether. Now, if you post that bond, then you'll be placed on tether with curfew hours. Let's see. Was that 4:30 p.m. to 3 a.m.? Mr. Crenshaw, in terms of the hours?
Yes, ma'am.
Okay. All right.
Mr. Crenshaw, that wasn't 4:30 a.m. to 3 p.m.
4:30 a.m. to 3 o'clock p.m.
Oh, yeah. Okay, all right. Hold on. So your curfew will be 5 p.m. to 3 p.m.
I will not have to work tomorrow.
Well, sir, if you post a bond, then you can work tomorrow. Right now, you have a bond that has been set at $50,000 cash surety. And so, is that unaffordable, Mr. Brico?
Yes, Judge. Any amount of bond would be unaffordable for my client.
Okay, all right, then there's a bond redetermination hearing that's scheduled for Monday, the 16th, June 16th at 9 o'clock. And that'll be before Judge McConicle or Judge Williams. And again, curfew hours, 5 p.m. to 3 p.m. I'm sorry, 3 a.m. if you post this bond. Okay, that concludes. Oh, no, I'm sorry. I also have included that you not have any contact with the artesian location. Okay?
Judge, did we receive the PCC and the exam date? I might have missed it.
Okay. No, I missed it. June the 20th is probable cause conference. That's scheduled before Judge Taylor at 8:30 by Zoom. And then he has a right to a preliminary examination. That's scheduled for June the 26th at 8:30. However, that will be in person before Judge Taylor in the 36th District Court.
Your Honor, could you also impose the condition of no alcohol, please?
Yes, I did check that.
Thank
No
you.
alcohol. Okay. All right, that concludes this matter.
Mr. Crenshaw, I see your hand up. You have the right to speak and ask questions. I would only ask questions about your court dates or your bond conditions. I wouldn't say anything else, especially with the prosecution being on the screen with us today. Nothing you say is going to change what just happened today. You will have a rehearing on Monday with the chief judge of this court to determine if they can lower that bond or possibly even reduce it to a personal. That's just something we have to wait on. I wouldn't speak about your case with anybody here in jail on the jail phone. Nobody else but your lawyer, sir. All right.
Okay, all right, then that concludes this matter. Thank you.
Thank you, sir.
Okay, your name, sir?
Christopher Howard Brewer.
All right, one moment. No alcohol. All right, good afternoon, Mr. Brewer. Okay. Court is calling case number 2505814-201. The people of the state of Michigan versus Christopher Howard Brewer. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Judge Miguel Abrico appearing on behalf of Mr. Brewer. My client's been advised of his constitutional rights, waives the phone when reading the complaint, stands mute, requests a not guilty plea be entered on his behalf.
All right, then the court will enter a not guilty plea on behalf of Mr. Brewer. By recommendation, Ms. Coyle.
Your Honor, I see Mr. Brewer being a 20-year-old male that has a little bit of a history. He has a 2020 assault and battery as a juvenile, a 2020 home invasion second as a juvenile, and another 2020 home invasion second as a juvenile. This involves a shot spotter alert to the area. Officers who go there approximately within 10 minutes of hearing the gunshots. They heard 25 shots allegedly were on that spot shotter. They observed the defendant with others he has a backpack, exit a vacant building. And then he basically bladed his body from the officers. And in that backpack, they recovered a gun with a 30-round magazine and also a live 9mm round and another magazine capable of holding 30+ rounds. So he said it was for protection. And anyhow, I have no objection to a personal bond, but I'm asking for a $5,000 personal bond. I am asking for a tether. 20 years old with that type of weapon and ammunition and a recent juvenile history. So that's what I'm asking.
Mr. Brico, your response, please.
Judge, on behalf of Mr. Brewer, no objection to personal bond. In regards to tether, just to state a few things, I would always leave it in this court's discretion on a matter like this. I oppose tether requirements just in consideration of the personal liberties we're afforded with our privacy, and if we can narrowly tailor bond without impeding or infringing on that. Judge, he's 20 years old. The allegations that are stated, he's presumed innocent of at this very moment, and perhaps will remain innocent unless proven guilty beyond a reasonable doubt. He just started a job at Captain Jay's. He's supposed to start on Monday, and I just wouldn't want a requirement like that to affect anything. I would request a personal bond on the matter, leave the memorization at your discretion. Obviously, you see where defense stands on that position.
Okay, thank you. All right, the court has heard the arguments of counsel and had an opportunity to review the investigator's report. Ms. Coyle, while there were some allegations there, the only charge that appears to have been authorized was for the carrying concealed weapon. Doesn't mean it's not serious, Mr. Brewer, but the court is going to impose a $20,000 personal bond. While you're on bond, sir, you are not to possess or purchase a firearm or any other dangerous weapon. You have a probable cause conference that's scheduled for June the 20th at 8:30. That will be by Zoom before Judge Robbins. And then you have the right to a preliminary examination. That's scheduled for June the 27th at 8:30. However, that will be in person before Judge Taylor here in the 36th District Court. There's nothing further than that concludes this matter.
This way.
All right, sir, good afternoon. Your name, please? All right. Court is calling case number 25058140101. The people of the state of Michigan versus Dwayne Leroy Howard. Appearances, please.
Coyle appearing on behalf of the people.
Mr. Brigo? You might
Sorry,
be on
Judge.
mute.
Miguel Brico appearing on behalf of Mr. Howard. Judge, my client's been advised of his constitutional rights, waives a formal reading the complaint, stands mute, requests a not guilty plea be entered on his behalf as to all counts.
All right, the court will enter not guilty plea on behalf of Mr. Howard. By recommendation from the people first.
Your Honor, the people are recommending a 25,000 cash surety with a tether. Mr. Howard has, I don't see any assaultive convictions. I see a 2013, two drug convictions in 2013, felony drug convictions. But the allegations are serious, and allegedly he was riding a four-wheeler and pointed a gun at not one, but both complainants, Ms. Hammonds, Ms. Gonzalez. Officers get a description. They see him later standing with four other men. No gun was recovered at that. Your Honor, I do see a note in the prosecutor's file dated today. There apparently some issue that the defendant is upset with one of the complainant's sons. She has filed multiple reports with DPD between May and June regarding the defendant. The complainant, Gonzalez, I believe, is the defendant's girlfriend. And they also described the gun in detail and that he racked it. So based on that, I do note that they didn't charge a felony firearm because no gun was recovered. So, but for these reasons, there are not one witness, but there are two witnesses in this case. And this is very serious. This just allegedly occurred on the 10th. People are asking for that 25,000 cash surety with a tether and no contact with either complainant. Thank you.
All right, before we move forward, Ms. Koyoff, reviewing a complaint and the domestic violence charge, it appears that is Ms. Hammonds.
I'm sorry.
Gonzalez. I just want to make sure.
I couldn't tell by the way the note was written to make sure that was, because the way the note was written, and I was confused myself because I looked at that and then I looked at the note, and so I'm sorry.
Okay, that's all right. I just want to make sure we get the parties right. Your response, Mr. Brico?
Judge, on behalf of Mr. Howard, beginning with, as we're all aware in this court, we begin at 36. We begin at most of our bond hearings from the initial starting point of a personal bond. And then we move from there based on any clear and convincing evidence that this court find that this person may be a danger to the community or a flight risk from appearing in court. Judge, I just want to touch base. He has 4 counts against him at this very moment, 2 of which being the assault with a dangerous weapon where no dangerous weapon was found. The count 3 being an assault or resist or obstructing on a police officer, which on the report itself, it states that he bladed his body, stood in an aggressive manner, and then the very next sentence states that the defendant then cooperated with Scout 9-8. I don't know how meritorious this argument will be on a assault, on a resisting, obstructing of the police officer. And then we have the count 4 of a domestic violence, presumably coming up from that count 1 and count 2 with the assault with the weapon, which the weapon was never found. Judge, the likelihood of conviction on all 4 of these counts, if any of these counts, I believe is very low. I know this is a consideration that we take under MCR 6.106. In addition to that, Judge, my client is gainfully employed. He works at Milton Manufacturing on 7 Mile and I-75, 7 a.m. to 4:30 p.m. Monday through Saturday. He states to me that he does not have any reason to be in contact with any of these complaining witnesses, that a no contact order would suffice. No contact, he understands what that means. We discussed it during our conversations. I believe any amount of bond will be unaffordable for my client. I would request a personal bond. I discussed with my client the possibility of a tether to protect the specific complaining witnesses on this matter. We have no objection to a tether if this court deems that fit. We definitely have an objection to any monetary bond, Judge.
Okay, thank you. Of course, heard the arguments of counsel and reviewed the Investigators report. I've reviewed the complaint. There are 4 charges here. The 2 FAs carry up to 4 years, and the police officer assaulting carries 2 misdemeanor domestic violence is 93 days. These are serious charges, Mr. Howard. I don't know what's going on. You know, these relationship issues seem to really spiral out of control, but there has to be a better response to breakups and disappointment. The prior offense that I see looks like it was 2013. Correct me if I'm wrong, he's not currently on probation or parole, Ms. Coyle, Ms. Rico.
Not that I'm aware of.
Me as well, Judge, and I believe that that prior charge was a non-assaultive charge.
Court will set a $50,000 personal bond. The court will pose a tether. Mr. Howard, you have curfew hours of, let's see, you work, what did you say? 7 a.m. to 4:30 p.m. So you have 7 p.m. to 5 a.m. as your curfew hours. Sir, you have 2 court, oh, you're not to have any contact with Katrina Hammonds. And I'm going to add, let's see, was another, I'm going to add Isabel Gonzalez Perez also to that, no contact provision. And you're not to purchase or possess a firearm or any other dangerous weapon. Is that understood? Okay. You have a probable cause conference that's scheduled for June the 20th at 8:30. That'll be by Zoom before Judge Jakay. Then you have the right to a preliminary examination. That's scheduled for June the 26th at 8:30. That one will be in person before Judge Jakay in the 36th District Court. There's nothing further. That concludes this matter.
Your Honor, how much was the,
$50,000 personal.
thank you.
You're welcome. But with tether.
Thank
Okay. Sir, good afternoon. Your name, please?
How you doing, Your Honor? My name is John Ferguson.
All right, how are you, Mr. Ferguson? Give me one moment. I'm well, thank you. Mhm. Okay, that's it. This one.
I'll let you know.
Okay. All right, this is Ferguson. Court is calling case number 250581430. The people of the state of Michigan versus John Lee Ferguson Jr. Here.
So appearing on behalf of the people.
Judge Miguel Brico appearing on behalf of Mr. Ferguson Jr. My client's been advised of his constitutional rights, waives a formal reading, stands mute, requests a not guilty plea be entered on his behalf.
A court will enter not guilty plea on behalf of Mr. Ferguson by recommendation from the people.
Your Honor, allegedly he had pointed a firearm at his son and then tried to stab him with a knife. No gun was recovered. I do note he has a 1994, it's a CCW, but his record is old, mostly theft convictions. Mr. Ferguson is 62 years old. I see that this is the complainant's resident. So I believe that a 50,000 personal bond with no contact with complainant Devontae Ferguson should suffice since they do not reside together. So I have no objection to that.
What's your position, Mr. Brico?
Judge, no objection to the people's recommendation.
All right. Mr. Ferguson, this is a very serious charge, but the court is going to impose a $50,000 personal bond. You may not possess or purchase a firearm or any other dangerous weapon, and you may not have any contact with Devonta Ferguson. Is that understood?
And Your Honor, I would also
hold on.
ask for a condition he's not to have any contact with the Chalmers Street address as well.
Judge, may I ask you that? I discussed that with my client because it does appear, the complaining witness is his son. It does appear that they either both listed as their address or both claim to reside there. My client indicates to me, Judge, that is his home. His son is homeless. His son is on drugs, and his son has a theft problem, and his father allows him to live in his home. So Mr. Ferguson Jr. has said to me that the Chalmers address is his home. Upon leaving the DDC today, he's going to go get a PPO against his son. And he's told me this. I expressed to him that the court might bring this up and might state to not go back to that address. He was frustrated, understandably, that that's his home, and we're going to be telling him today to not go back to that home. I told him as a last resort, is there somewhere else he can stay? He did provide me a street name and claims it's going to be his mother's house. Before we get that far, I just wanted to bring this to your attention and see perhaps that is his home, as he indicates to me, and we would be telling him not to go back to his home and instead allowing his son to live there. I'm not negating the fact that his son might have some legal definition of a tenant right. I don't know that, and I'm not here to litigate that, but I did want to put it on the record for you.
I guess
Okay,
I
thank
just
you.
want to say that based on what I see, Your Honor, and his statement, Mr. Ferguson before us, he does give that address as his on his statement to the police. But I do see another address given on the IR. So the point of my personal recommendation was, or personal bond, was that they have no contact if the complainant lives at that residence, because we're just asking it to fuel right back up if they're both allowed to go back to that residence. So I think it has to be a no contact because these are very serious allegations.
Okay, so Mr. Ferguson, sir, unfortunately, this court is a criminal court. There is a division here regarding landlord-tenant. I do have an address, Mr. Brico, on Park Grove Street that's listed on the pretrial release form for Mr. Ferguson. Is that a
Yes,
place
sir.
that he can go to?
Yes, Judge, he indicates that's his mother's home.
Okay, so maybe those facts can be ironed out. Maybe the prosecutor can check and see if the other complaining witness in this matter is still there or not before the next court hearing. But sir, based upon the volatility of this situation, Mr. Ferguson, you should probably listen to the court. Based upon the seriousness of this matter, at this time, the court is not going to allow you to return to that location, specifically since I have a different place on the paperwork where you can reside. And hopefully the matter will be resolved soon. Okay?
Honor, I understand what you're saying. I'm gonna do what you say, no matter what, but Your Honor, my son,
Sir.
Okay.
And I know there are other issues that the court is not always privy to, and sir, but again, unfortunately, you're the one that's charged, and so this is how the court is going to rule today, okay? But you can take that matter up later.
Okay.
You have a pretrial, you have a probable cause conference that's scheduled for June 24th at 8:30. That'll be by Zoom before Judge Giles. And then you have the right to a preliminary examination. That will be July 1st at 8:30. That one will be in person before Judge Giles in the 36th District Court. And if I didn't indicate, you may not possess or purchase a firearm or any other dangerous weapon. Okay, all right, that concludes this matter.
Thank you, Your Honor.
All right, sir, you're welcome. Take care.
You know.
That right there.
They already gave me a court date.
I'm sorry, sir, your name, please? Did he say what his name was? I can't hear you.
I can only hear in one ear.
Okay, can you state your name, please?
Richard Bill.
All right, thank you. All right, Mr. Ditto has some tickets, so I'm gonna address those first. Mr. Ditto, you failed to appear for support hearings and there were bench warrants issued.
The guy told me my bond was $100 and I had a court date for December 5th or something like that.
Okay.
But they didn't have.
Let me get
here. I might gotta have my pay $100 and they don't have any.
All right, just listen on the tickets because I'm gonna set a personal bond on the ticket, but let's get there first. All right, you failed to appear and there were bench warrants issued, so I'm gonna set those bench warrants aside. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Court is calling ticket number SP 909096. Indicates that on 8/7/2018, you had improper plates. Ticket number SP 910332, 8/7/18. You have driver's license never acquired, no insurance, and driving an unregistered vehicle. Case number 184894021, 9/15/18 says driving an unregistered vehicle. Case number 184894022, 9/5/18, driver's license never acquired. And 18/4894023, 9/5/18, improper plates. So with those charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. Court is going to enter a not guilty plea on your behalf. I'm going to set a personal bond, so you don't have to post any money on those tickets. You do have a pretrial that's scheduled for June 26th at 8:30. That'll be by Zoom before Judge Sherman, okay? And they'll give you some paperwork before you leave the jail, so keep that in mind, okay? I need you to restate your name for the record.
Richard Ditto.
Okay, court is calling case number 24045600701. The people of the state of Michigan versus Demetric Charles Ditto. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Judge Miguel Brico appearing on behalf of Mr. Ditto. My client's been advised of his constitutional rights, waives the formal reading of the complaint, stands mute, and requests a not guilty plea be entered on his behalf.
All right, court will enter a not guilty plea. So there was a capious judgment. Let's see. He failed to appear for a pretrial. There was a $1,000 10% bond, and that was on 12/5/24 set by Judge Lanice Bryant. Ms. Coyle, your recommendation.
People are recommending that bond remain the same. I see this, he was given a personal bond at arraignment in July of 24, and he failed to appear 2 times till December of 24. So for that reason, I'm asking the bond to remain in place. Thank you.
Judge, on behalf of Mr. Ditto, the underlying offense that even brings us here today, which he capious from, was a refusal of fingerprinting, a 90-day misdemeanor and or $500. I believe Mr. Ditto is 63 years old. I see from his prior intake sheet, from his initial arraignment, we have on here that he is hard of hearing. He does have a seizure medication, a high blood pressure medication that he's required to take. He does volunteer at senior citizen centers, soup kitchens, etc. Judge, it's not the crime of the century that he's missing court on. He shouldn't be missing court. We understand there's a certain respect to pay to the court and showing up for these court dates. I'm not going to provide an excuse right now on why he didn't show up. I just would like to let this court know that we would be holding him for not having money, essentially. It's $1,000, 10%. We're talking about $100. I would request to convert this to a personal, allow Mr. Ditto the chance to reappear to these hearings, take care of this minor matter, a situation where he probably wouldn't even be getting as much time as he's going to spend in pretrial detention if he were found guilty of that crime, Judge. I would request a personal bond. I have no issue with any other requirements. I don't like tether. Sometimes the tether holds up our clients in the jail just trying to get out. I would really request personal bond on it, Judge. I appreciate your consideration.
Yeah, thank you. Well, yes, I did. Yes, thank you. So, this was a fingerprint refusal, looks like going back, let's see, 7/18/2024. So, Mr. Ditto, you have to come to court, sir.
Ma'am, I didn't, miss, I was coming from the laundromat with my clothes, and the guy asked me my name, I picked my name, he said, put your hands behind your back, you're under arrest. I was coming from the laundromat. Warrant a year ago, I didn't know anything about.
The case, okay. All right, well, now you know.
I'm armed just
now you know.
Twice.
Okay. All right, so now you know about the case, so you have to come to court. They're gonna give you some paperwork when you leave the jail. You make sure you keep up with that paperwork. And appear, you have a pretrial that's scheduled for June the 25th at 8:30 before Judge Bryant. So the court is going to set $1,000. Oh, wait. Oh, they put it in here. No, they checked the box before I guess they realized it wasn't a misdemeanor. Okay. Yeah, I'm gonna set $1,000 personal bond. You have to get to court though, sir.
Yes, ma'am.
And if you can't get on Zoom, then just come down to the courthouse. All right?